everything's transferred outside of the estate via beneficiary designation, you've really made it harder for the people that have to take care of things after you're gone rather than easier.
Claire, as a lawyer who's not an estate planner, I'm interested in beneficiary designations. They're compact, they're efficient, they're effective. What's the purpose of a beneficiary designation form?
So a beneficiary designation form is something that you, as an account holder, would put on an account that is in your name. And what happens with that is, upon your passing, that account passes to the individuals or charities that you've named as the recipients on that beneficiary designation form on filed with the custodian of the account. In easy terms, that is putting your spouse or your children as the beneficiaries on a designation of beneficiary form for your retirement plan or IRA.
Many people use beneficiary designation forms for the retirement accounts. What are the various types of accounts that allow for those forms?
You can put a beneficiary on almost any type of bank account or brokerage account. Sometimes it's referred to as a transfer on death, or TOD, or a pay on death, which is abbreviated as POD. And that is the designation you would use frequently on a checking account or a savings account. You can put beneficiaries on CDs. You can put beneficiaries on brokerage accounts, retirement accounts, IRAs, as you mentioned, life insurance policies, annuities. All of those frequently have beneficiaries, and there's pros and cons to naming beneficiaries on some of those different types of accounts.
Someone recently told me that all they have is financial accounts, so they don't really need estate planning. All they'll do is beneficiary designation forms, and they're good. Do you agree with that?
Sort of. Beneficiary designation forms are part of a good estate plan, but they themselves are not usually the most efficient estate plan. Because when you use beneficiary designation forms to transfer all of your liquid assets, you have now taken all of the liquid assets out of your estate, which seems like maybe that's a good idea. But at the time of your passing, there are still going to be expenses that your estate has. Income taxes, expenses associated with your funeral, final medical bills, your credit cards, even utility bills sometimes are left remaining at somebody's death. And if there are no assets in their estate to allow somebody to take care of those things because everything's transferred outside of the estate via beneficiary designation, you've really made it harder for the people that have to take care of things after you're gone rather than easier.
When you fill out a form, a beneficiary designation form, can you just stick a minor's name in there?
You can. But again, maybe not the right path. If you are transferring more than $25,000 to that minor, then someone is going to have to petition the probate court to be appointed the conservator for that minor to take custody of those funds. That's going to generate a requirement of a reporting to the probate court every year on the status of those funds. If it's less than $25,000, those funds can go into a custodial account for the minor, which is a more simple structure, but there's no court oversight over that. There's actually no oversight over that. And what's more, when that minor reaches the age of 21, now that minor is entitled to whatever's in that account. And you may or may not want your 21-year-old to actually be in charge of a large sum of money. So again, with leaving money to a minor via a custodial account or a conservatorship account, you're giving up the opportunity to exercise some control over how that minor has access to and benefit of those funds.
So can the designee be a trust? I mean, even if it's not a minor situation?
You can use a trust as a beneficiary on almost all accounts. And I say almost because with some accounts you have to do a certain type of trust as the beneficiary. It's not just any trust and any account. But yes, using a trust as a beneficiary is a more efficient way to transfer assets, especially to minors, but also perhaps to special needs beneficiaries who aren't minors but might not also be able to take care of funds on their own. Or if you want to leave money to a spouse, but you might not want that spouse to exercise complete control over those assets, you can put a trust in place as the beneficiary for those funds that you want to pass to your spouse or want to pass to a child or any other beneficiary.
You recently told me that if an owner of a financial account is ill, it may be effective to use a beneficiary designation form. You told me that it's a slick way to handle things.
Yeah. Sometimes we get that call, mom, dad, grandma is not doing well. What do we need to do? Is there anything we need to do? And sometimes when time is short, you're very limited with what you can do. Oftentimes my advice is check the beneficiary designation forms on the accounts. Make sure there are beneficiaries on accounts that should have beneficiaries, IRAs, retirement accounts. It's a really, sometimes can create some really bad outcomes if there's no beneficiaries on those accounts. So taking that last opportunity to make sure you've got beneficiaries on accounts sometimes can really save some trouble for the family. Likewise, the accounts may have been put in place years ago and have beneficiaries on them that aren't right. It could be a former spouse. It could be a deceased spouse. This is the last chance. If the right documents are in place to allow you under a financial power of attorney to make those types of designations for somebody who's kind of at the end stages, that's a great tool to be able to exercise. Also, sometimes your parent, grandparent wants to do something. They might not be up to doing a full estate plan, but they could do beneficiary designation forms. And so it's an opportunity for them to kind of double check and make sure things are in place.
In some probate estate lawsuits, I've seen an issue where after a divorce, the spouse doesn't change the designation form and the ex-spouse doesn't change the designation form, and then that ex-spouse dies. And then there's a question as to whether the divorce agreement properly terminated the beneficiary designation.
Yep.
It's important for people who get divorced to revisit their designation forms, update their designation forms. Have you dealt with that before, Claire?
I have seen that, and there's a lot of case law about that and the dispute that the divorcing spouse had the opportunity to change and didn't. So therefore, it's deemed to be that they didn't intend to change it. And so you end up with fights between the former spouse and sometimes a new spouse or the estate to try and claim back those funds that went to the former spouse. Former spouse wins in that case frequently because the deceased person had the opportunity to change and just didn't. And so, again, over the years, I've met with a lot of clients. We talk about these subjects ourselves, but making an effort to check your beneficiary designations regularly is important. After a life event, after someone's passed away, after a divorce, after the birth of a new child, after a marriage, these are the times when you need to think about whether the old forms that you did when you set up those accounts, when you took out that life insurance policy, are they really still reflecting what you want in place for your planning now? It was right then. It might not be right now, and it's important to check it periodically.
So what I'm hearing in general is you need to revisit the beneficiary designation forms, update them. You said when there's an important life event, just check them out again. Make sure you're disposing of assets the way you want them to be disposed of.
Absolutely. Good advisors will review them with you annually if you meet with advisors. Some custodians of funds send out a statement every year confirming who your beneficiaries are. If you don't have that type of relationship with a financial advisor, or you're not getting those types of forms from your own custodians holding the funds, make the effort yourself to double check those every year, every couple of years. A review with your estate planning attorney periodically is going to generate those same types of questions. And so I think it's important for everyone to look at their estate plan, look at their beneficiary designations as part of a review of their estate plan, because those things really should not work independently. They should work in concert to make sure that your wishes for the distribution of your assets happens in the way you intend for it to pass.